institutional payments in central government. But also for the last 2 years, I've been the policy lead on the new procurement bill for frameworks, dynamic markets, and associated London bits of stuff like KPIs, the transitional arrangements. So if I just go through what the UK landscape, so we have £380 billion worth of public procurement spend a year, of which about 37 billion goes through frameworks. So 10% of our procurement spend goes through frameworks. And we have thousands of frameworks. I think when I get to some of our problems, one of them is we don't have particularly good data. So we know we've got we think we've got 2,000 frameworks on construction because Francis Mosley came up with that figure. But when we do our own internal research, we come up with 1,200 on everything. So the data is not very good. So it's one of our issues. So we have that. Of that 37 billion, it's mainly what we call common goods. So it's good that we share across multiple contracting authorities, but it goes everything from works through to toilet roll. So everything's there. So the Crown Commercial Service, which is a central government department, which was set as part of the cabinet office right in the centre of government, it puts through £25 billion worth of business in 2021, 2022, which last year we got figures for. But we have twice the staff that the Italians do for the same sort of figure, so it's slightly different. But we our main driver is to get what we call commercial benefits. So it's the savings we can make if you were to go to any open market, which is roughly 4 billion a year. So it's around it's getting towards the 15% of the spend. But we have lots of suppliers, but we have dynamic purchasing systems. We have them, but they're not really used that very much in the UK. For some reason, they are used at a local level, but on a national level, they just they don't work. And I'm just fascinated with the Italian figures to see how you manage to get that much spend to because we seriously struggle. I think we struggle with the concept of the DPS doesn't really work for goods for us for some reason. I think we put it all through frameworks. And one of the things we're quite excited about, or I'm quite excited about going forward, is that we'll be able to do services. I feel DPS would be better for service, particularly with the supplier. So that's where we are now. If I just go through the challenges we've got. So the challenges, as I said, data is an issue. We also think we have too many frameworks doing the same things. So we don't tend to have small frameworks. We tend to have what we call big bucket frameworks. So it's IT. And that could be anything from a laptop to equipment. So we have ones for equipment, we have ones for services, but they're really big bucket frameworks. And part of our thinking going forward is that we probably want to have less, but we want to have more focused frameworks because they're not the quality is not consistent across the whole of the public sector. As I said, we don't use direct markets very much, but our frameworks are incredibly complex, particularly the building ones, and they are. I think we sometimes push the boundaries of what is acceptable to be on a framework, and I often have the conversations that even if it's just reading a framework, and trying to get people to think that maybe it's not always the answer, and not very successful at that point. And obviously, we like the frameworks simply because it enables us to get our SME spend up, which is particularly poor in the UK compared with the rest of Europe, particularly the way it's structured. But we use them to get the people on frameworks. But we do have, without having a lot of SMEs on there, does cause small problem in the sense that they complain quite a lot about the drop off every time a framework gets recompeted, because the time of the curve is very slow. And the last year and a half, they seem to be getting more business, the SMEs. And then when we reset it, it resets, and then they start again. So they have a curve of spend, which the large companies don't see. And we also have a small growing issue with private sector companies using claim contracting authorities to set up frameworks. So they will say, I'm setting up a framework on behalf of a school or a small municipal department, and then for several £billion. So it obviously disproportionate to the size of the business, so that anybody can go and use it. And we've had a recent court case where the framework was cancelled because it was clearly nobody considered the volumes in a way that was.
We wait for the reference.
I will find the reference, although Michael, we were quite sure if you were involved in it. Anyway, so there were similar challenges, and I'm going to just saying to Marco that we also. We've had I've had personal experience, and we've had a personal experience trying to remove suppliers on framework before the known court case was the court case the outcomes were known, or so again we've looked at that. So with all those thoughts in mind, when in the new procurement bill we've looked at obviously changing how we set up frameworks and TPSs. I should say that one of the key fundamentals that we've gone from effectively neat, most economically advantageous tender to most advantageous tender. So that will change, how we treat the tenders, mainly so we can bring in more of such value elements when evaluating the procurement. But in terms of the frameworks themselves, we've done a number of things. So firstly, we've sort of simplified the rules in the law, so that people can decide to select the competitive selection process as part of the framework. So that we will design that framework. We'll have the process set out, and that will be it can be unique to that one. It could mean that we have a single stage, or we have multiple stages. And this is partly to bring in because we under the new rules, all the defence and all the utilities and everything is under one set of rules. So, and in defence particularly, we use multiple processes when awarding contracts. So we often want to bring that into the frameworks. We introduced a new concept called the open framework. So that's a scheme of frameworks over a period of time, up to 8 years. And this is part of the challenge to deal with that SME drop-off. So the framework will be open for 8 years. It's not actually a single framework. It's a series of frameworks that run one after in a series, one after each other. But you could move the suppliers across on their original tender figure, on the original tenders. We've, as I said, we've effectively renamed TPSs to a dynamic market, but then extended the markets out to everything. So it's goods, services and works rather than just goods. As I said, we've now we've included something called excluded and excludable suppliers, which is a lovely phrase. Only a lot of written. Yeah, so but that means we can then remove suppliers from frameworks and dynamic markets when there is when they are excluded for other reasons and rather than the court case at this moment. And going back to the data issue, which is obviously our biggest issue, we're going to increase transparency, and in particular, there's going to be a register of commercial tools. And what we want to do is we want to stop that duplication. So obviously, we know the same suppliers are bidding for the same frameworks all the time, and so you can have a supplier on 20, 30 frameworks. And all that cost that goes into it, because the cost stays in the system, doesn't it? So we want to reduce that, hopefully get better value for money for ourselves. And so we've done that, and also we've tried to simplify the charging as well. So at the moment, we all agree that this is not personally but viable under the EU rules, but it still happens. People are charged to bid to get on the frameworks in some of these cases, and then they're charged another fee on top of the new business. So we've rationalised that down, so you can only pay a fee once you've won actually a call of contract, and that's part of that call of contract, a set percentage, and that again will be published, and that will be available through the register of commercial tool. So that's effectively what we've been doing. Let's see. I should say so. The open framework I said was 8 years. We've also sort of relaxed slightly the 4 years for a normal framework. So it's now up to the contracting authority to set. Say it's a road building scheme, and we know the road's going to take 6 years. They could extend it. They could set out at the beginning that the framework was going to be for 6 years because they were doing X, Y, and Z. As long as it was a reasonable rationale behind that. But also defence and utilities frameworks are also would be up to 8 years now. Because I'm in the central community, we stick rigidly to 4 years because it's the risk is often on the buyer using the framework, not us, and therefore we have to try and mitigate their risk to our. But if you're setting it up for yourself, then you would, as a contractor authority, then you've got a bit more leeway. I think that is about what I should say. New rules only cover England, Wales, and Northern Ireland. Scotland is keeping the same rules as ourselves, but obviously we are working behind the scenes to make sure that they can start using their fields. And particularly, there's a contractor authority in Scotland which is mainly for universities. And they set up frameworks for universities, so also we want to still carry on using that. And then obviously we, as a Grand Commercial Service, we want Scotland to keep using us because that's £100 million a year. So we're both going to be laying secondary legislation by March, so that we can carry on doing that. It's all fun and games. Yeah. But so yes, I think that's our main points. I think. As a practitioner, I've spent 2 years working as the policy lead, as the lawyers to draft this thing. As of the 1st of January, I go back into the Grand Commercial Service to design the products. So I'll be designing the new products. On your units? On my... I'm waiting for somebody to say that I can't do something because the rules are, no, you can't do that because the rules say this. But it will. It'll be interesting. But yeah, it's...
That's very interesting. Yeah. Now, do we have Michael, and then we ask questions all together, I think, perhaps, okay? Okay, hi, Michael. Go on.
Hello. Sorry I can't be with you. As I was... Oh, can you hear me? It's all dark.
Okay.
Oh, there we go. Yeah. As it was court that held me up, let me take a sort of court-based pathologist approach to the topic. As Rich has already given the practical users, the sort of legislative and commercial side of it. I mean, as you know, we've had framework agreements for a very long time in the UK. People always say, "Oh yes, yes," from the very beginning of the EU. No. The office where I sit in King's, we had framework agreements in the 17th century. So they're old things. We called them something different. Standing contracts, they were called, when the Navy procurement was done out of my office in King's. The issues I think what from a sort of things that go wrong point of view, I think I would simply say that framework agreements are they are a tool which are no better or worse than the users and their capabilities. And going back to John Luigi's point, I know that sometimes people get excited about there's something inherently good or bad about frameworks. I don't think there is. They are what they are, and you make what they are. Some people make very bad use of them. So if I take a pathologist's approach to it, it's not so much criticizing the idea itself. It is illustrating the ways in which they can be abused in interesting and different ways from maybe a classical, straightforward bilateral contract. So that I'll come on to that in a moment. But before I do that, I think it would be just to pick up a little bit on what Rich was talking about in terms of sort of distinctive use that has been made of frameworks in the UK and move beyond. I mean, I think one of the features which I'll talk about is the way in which we have this plurality of central purchasing bodies running multiple parallel framework agreements. Now, in a moment, I'll come on and say that's quite a bad thing, I think, but there are some strengths about it. There are elements of positive competition between framework agreements, although I think it has also created a number of negatives. But I think perhaps the most important aspect in this area where we have numerous CPBs is the positive use of frameworks in different regions for construction. And I think the use of frameworks in construction, albeit that it is often quite hard to reconcile the compatibility of the framework agreement with the definition of framework agreement as provided for under the legislation. If you accept that they're sitting on the edge of lawfulness, they're actually usually pretty good and effective devices, not least because they have proved in a number of areas to be very effective means of disciplining performance and ensuring that there is something over and above the purely contractual tools in ensuring positive contract performance, so that you can change. So that what has happened with some of these regional frameworks is that a positive performance outcome in one construction contract then leads to a change in the ranking of the parties on the framework for the next call-off. Now, one of the last things I had to do before Brexit was fight a very, very furious attack from the EU Commission, which regarded that as unlawful and contrary to transparency, because they said we were modifying the terms of the framework in the course of its operation. I mean, I just think that was wrong, and to some extent showed the incorrect hang-ups of the EU Commission on this point. The rules were very clear from the outset. It was always very clear that as to use the English phrase, points mean prizes. If you got better performance, got you more contracts on the framework, and I think that's a good thing, not a bad thing. But a number of people at Olaf found that quite mind-blowing. So there's a Brexit benefit for you, Gianluigi. We're able to separate from narrow-mindedness in Brussels. And I think this is important, and I did a talk about that in the building that you are currently in. I did a talk about this about 6 months ago on green frameworks, because I think the next step, which I know ties in very closely with work which Mario has been doing with David Mosey, my colleague at King's, and also with the University of Milan. I know they've been working on it as well, is using frameworks as a means of driving environmental benefits through the framework. Because if you can use the framework to drive better performance, just traditional contract performance, then you can do the same to drive better environmental performance, and that leads into if you can tie that in with an enhanced use of the IT tools such as building information management, then you can actually have some very powerful tools through the framework to drive better environmental outputs from construction. And given whatever the figures are, concrete accounts for X% of our carbon, and macadam accounts for Y%. If you can make a dent in concrete and blacktop for roads, you're actually making a significant contribution to the national carbon budget. So that I think goes in very much the positive slot, and I could talk about other positive things, but it's more fun to be negative, isn't it? So I don't know how many more minutes you want me to go on for, Mario. I can only see you very. Sorry.
You have all the time you need.
Okay.
Michael, sorry, I don't know whether you're going to look into the chat, but I need to make this point very clear in front of witnesses. I am very much interested in all the historical aspects of framework agreement. And I would love to, actually, this is my ambition when I get older, to become a historian of framework agreement and to show that may be at the very early stage the most sensible user framework, where exactly those ones before they were manipulated by the European Commission to become some sort of extremely rigid and robotic purchasing vehicle. So I would love, so I'll send you maybe a separate email
We can
about
talk
that,
about
if you don't
I mean,
mind. If you don't mind.
there is actually a whole piece about the Royal Navy uses standing contracts in the 17th and 18th century, particularly for things like ropes and anchors and things like that, where they needed to have large supplies ready to go at short notice.
Ready to go.
Yeah. And that was part of the problem, because the capital investment requirements to be on those standing contracts was often very high. And if you have to make an anchor, this is a problem for today as well. But I also often use it with my students, because it's very easy. It's often much easier to explain than some of our sort of IT related problems. But if as a term of being on the standing contract, you have to have ready to go at any given time 2 anchors that will go on a 3-deck battleship. Now the cost in 1750 of the anchor of the main anchors for a 3-deck battleship were enormous. And how many are you really going to sell? And so these contractors would often be broken by if they couldn't renew the standing contract, they would be broken by the fact that, of course, the successor to the standing contract would buy up the old stock at ridiculously low prices.
Right, exactly.
And so there was a defect in the system, because, of course, that led to interesting economic incentives at the time of handover from one operator to the next. Now,
Awesome.
I think some laws of economics are probably constant, and I think I've probably seen similar things happen in the 21st century. Anyway, negative. Maybe I've glided a little bit into negativity there. And then a related. Let me tell you a story which I think illustrates a number of interesting problems. I'll have to be a little bit neutral about it, but we're talking about an ICT product which has some hardware and some software, and which is bought in most of the UK on a fairly granular basis by hundreds, if not thousands, of individual purchasers off a DPS, not a framework. And it's important stuff. One region of the UK, though, for political reasons, largely dressed up as economic reasons, says, no, we want to buy centrally for all of the entities in our region. And because they say this gives us better purchasing power, and we will be able to drive down prices. They don't succeed in driving down prices. The basic problem is that this is a region where it is just more expensive to deliver the service. And the political control reasons are perhaps a little bit Stalinist. What then happens, they come to they reach a crisis at the end of the framework, because the end of the call-off contract, because the DPS has expired, the contract expires, they make a mess of the re-procurement, which they decide to do on an individual basis. As a result of which they're 2 years behind, and they find that they now no longer have access to the IP rights in the software on which an entire part of the national public service depends. And so they simply turn around and say, well, we are who we are. We are going to carry on using your software in breach of copyright, which is itself a crime. And in breach of other IP rights, and in breach of contract. There's then some litigation which was settled earlier this week, on the terms I have to be a little bit careful what I say, in which a large sum of money had to be paid to the operator, But in order to try and get around it, what they end up having to say is that the provider of the software and hardware is in fact acting in breach of and abusing a dominant position by insisting on recontracting on its terms, on the terms it insists upon for an interim period, and in breach of procurement law. And therefore, the alternative to the breach of procurement law and the breach of competition law is that they should be able to use the IT without actually having the relevant IP rights for the IT. That they are entitled, because they're the government, to basically trample on people's property rights, which creates quite a nice case. Unfortunately, of course, the competition law argument is rather flawed, because the only reason why the operator has a dominant position is because
It's because of
by the government.
it's good about the framework agreement, right?
Exactly. It's been structured so. I mean, it would have been quite a nice case to fight, to actually find out what is to what extent it is really a dominant. Do you really have a dominant position? If your dominant position is only temporary because it will end at when there's a rebid.
And on the top of that, Michael, it's the outcome of a competitive process. So
exactly,
it's double.
And you've been given it. And other parts of the country, the market operates differently. So demonstrably not a. So it would have been an interesting thing to operate. Anyway, I mean, just illustrates that authorities think they're getting the best out of framework agreements by using their centralizing features. They can, if they haven't thought it through, and if their competence isn't up to it, they can end up making actually life worse for themselves.
Sure.
Because if they just carried on in the basis that people do in the rest of the country, they would have just been able to roll on with lots of individual contracts. So it's an interesting, an interesting problem. I think that I would say I do think that from my perspective, therefore, I mean, when I see framework agreements, they tend to be ones where sort of there's been some serious deficiency in procurement competence, if I can put it that way. I mean, for example, one framework fairly recently, a medical framework, where the price assessment was done on the basis of a reference product which is not licensed for use in the United Kingdom. I mean, so not surprisingly, everyone just put in absurd prices because they knew they were never going to. They knew they could never be asked to provide it, and it took some time before anyone noticed. Before anyone on the purchasing side noticed that the sellers were having, as they say, a laugh. Other problems, yeah, and I think this multiplicity of framework problem is an issue because there is a complete lack of transparency often in the way in which choices are made as to which framework or which DPS to use. The regulations obviously don't deal with that choice directly. We have tended, as litigators, we've tended to sort of amongst ourselves always assume that the general obligation of transparency and equal treatment must apply to that choice in some general sense, because it is a procurement. It can be as much a procurement decision as an award decision, depending on how the frameworks are dealt with. But we've never really directly dealt with that, and it will be interesting to see how that works out in the new law, which is going to be quite different in a number of interesting ways. And what was the last thing I was? And because we have this competition, and because so many local authorities are under so much financial pressure, the temptation for some of them to use their CPBs as cash cows to support their other activities is quite strong. And without naming names, some are better than others, let me put it that way. And some of them become so privatized, it is really hard to see how they can possibly regard themselves as continuing to be public bodies, because they're obviously just private commercial entities traveling under the name of some local authority or whatever. Now, some are better than whether that's a good thing or a bad thing, it's not compliant with the current law anyway. I'll stop there because maybe I've provoked enough questions, and I might start getting scandalous in a moment.
Or not. But I need to make a, I'm sorry you guys intervene. I need to make one simple comment that in the past 10 years, this is the first workshop in which, keeping me as an exception, I've heard, comments about framework agreements in terms of it depends the way you use it, which seems to me the most obvious observation. And Mario knows very well that I've spent some years, a little bit fooling around with a colleague of yours in the UK, although he's not a Brit, trying to persuade him that it is a very bad exercise to pretend that it's something in the law which is, kind of genetically bad or good. And rather than preaching the idea that the way you do things matter. So, and actually it's surprising because the UK is the country where this is taught, even in primary schools. There are fundamental, I would say, there are fundamentally logical stuff to be taken into consideration. But after that, it's a matter of thinking, of designing, of building things. There is nothing which is intrinsically bad, because if we embrace these theses, that would be that the European Commission is a bunch of nuts. That's it, which cannot be, also for statistical reasons, cannot be all the nuts are in Brussels. I'm also a statistician, so cannot be. So it serves the cause of having a logical approach to public. What you're saying, Michael, that it's a matter that sometimes this is a very things to be handled with care. So you need good people doing that. So the only thing that I would add to what you're saying is that you may have, normally we tend to believe that CPBs are in a better condition than others to do that, although this is not necessarily the case, because we know there are better in CPBs and other bad CPBs. So you need competence to do that for things much better than for standard contract. But I'll stop here. Thank you, actually. Thank you, Michael. I'm very happy you said what you said.
Yeah, okay, yes. Well, Gianluigi, thank you. Yeah, as I said at the beginning, this is a seminar with a very practical and empirical approach, and this is the result. I'm very happy. Finally, the approach is empirical, and it depends on how it's used. We are here just to find out what are the best practices in using the framework agreements, and perhaps what to suggest to the Commission in order to have better regulation. We have to have some dreams sometimes, also for framework agreements. Now, any questions? Okay, Magdalena, yes, I know parallel framework agreements have been cited, so you have.
Yeah, thank you. Thank you for the presentation. My name is Magdalena Socha, and I'm writing a PhD about parallel framework agreements. So I have a question to Michael, because you said that there is no transparency at all regarding the choice among the parallel agreements. So do you have any idea what could be a possible solution to shred some transparency to that choice? Prohibition of parallel agreements, or maybe something else, like introducing the rules on choice in the contract notice for framework agreement, but then in which one? How to tackle this issue?
It's maybe a question more for Rich than for me, but let me have a. Unless, can you think of, Rich? Can you think? I can't think of any way in which a framework choice is made transparent. It might be on the website or something, but other than that.
No, I mean, we did actually think about this when we were designing the new rules, because as I said, we've got too many frameworks. But my view is we've got too many frameworks, and therefore, how would we limit the market? And we've gone for we can't tell the local government that they have to use CCS because the way that the UK is set up in its rules. So we've gone for the transparency approach. We're going to put up all the frameworks that are let into the new rules, so they will be visible. So we would encourage people just to use common sense to say, look, there's something there already. I don't need to go and do it myself. So that's the way we're thinking. And we'll know in 6 years whether it's worked or not, won't we? So that's the approach. But it doesn't really answer the question about the transparency of how you make that decision. What we're trying to do is just trying to reduce the opportunity.
But what I'm wondering, I mean, I hesitate, Magdalene, because our new law was it was made law yesterday, but it doesn't come into force for another year. Because we've been talking about it for a long time, many of us have I haven't read it every single day. In fact, one of the biggest changes in it is going to be the transparency regime, which is quite detailed and has not yet, that is being set out in secondary legislation, which itself is still being worked on, although there is a running draft. And that is one of the parts of the law which I would say looks most different from the EU model, from to the new model we'll have running in a year's time, God willing. That includes something called a pipeline notice. And I'm not sure that, I don't know, I've not yet got dedicated enough time to looking at the new regime. You may have done, Rich, I don't know. I don't know who in Cabinet Office has been dedicating their life to that side of the regime. But you could certainly imagine if you as an authority had to identify the pipeline of purchases which you were going to make in the forthcoming period, and that was made compulsory rather than purely indicative as it is in the current regime, you would then be able to make certain deductions.
So you have to use AA to analyze how people are purchasing with agreement, I think.
Yeah, there's one small flaw in this that call-off contracts are not required to be published on the pipeline. They're only voluntary.
Why that? Why was that done?
I don't know. It's one of those weird, wonderful things that was written by somebody else rather than the person who's trying to frame it. So it was something that it was done by the time we realised it was too late to change it. But yeah, so I mean, we already, and the guidance is going to say we encourage people to report any major procurements are going to be off the call-off in there, but it's not part of the requirements.
There is not an obligation to publish your results?
There is an obligation to publish the results, but not obligation to say up front you're going to. So say I want to order £10 million IT contract and I'm going to put it through a framework. I don't have to say a year in advance that I'm going to do that. But if I wanted to go to market for £10 million, I would have to tell the market it was coming. So it's not a requirement. Obviously, if you set up a framework, that has to go in the pipeline, but not the actual call-off.
Because in France, we are working on a platform where public entities are going to say what they are going to launch as framework agreement publicly. So it's a way to
We'll say the frameworks themselves, but not the actual call-off contracts. I think there's an assumption that there's been some market engagement beforehand for this.
Substantially, there was no answer to your problem because I think what Richard is saying, and they are trying to reduce parallel agreements. So it's a question of avoiding the problem. But if parallel agreements are technically possible, as far as now, I think we are waiting for your thesis. But I think I remember, but I must be wrong. I remember one seminar in Copenhagen, I can't remember which one, but perhaps a year ago with some people from SKI, and I tried to make some questions on this point. And they told me that when they before launching a framework agreement, of course, they make inquiries for asking what are the needs. And then they ask contracting authority to sign a kind of obligation to use this specific framework agreement. Is that correct?
That's
so
correct.
if they do like that, you eliminate the problem because it is not anymore parallel.
But if the problem is if they have their own contract on the side, then you actually have parallel contracts as well, not by the same bodies, but the same supplier. That could be
Yes,
a
but the point is, if I am a municipality and or a small contracting authority and I have to buy pens, I can select, in theory, a contracting authority, one by CONSIP, the other one by my region, and the other one by someone else.
Yeah.
Unless I am obliged to buy by CONSIP, because CONSIP tells me, are you interested in this future contracting authority? Please sign an obligation to buy. So I don't have any more of a choice.
Yeah, that's true.
So this can be a radical solution, but I was wondering if it is compatible with internal legislation, but I can't see any.
It's a contract.
It's
a contract. Yeah.
No?
This is what they do.
What do you say, Magdalena?
I would say it's not really clear. Like you can interpret the directive in both ways. And correct me if I'm wrong, if I understood well, in France, framework agreements are mandatory to use like per definition. So there is no issue of parallel agreements, and somewhere else, framework agreements are interpreted differently, that there is a freedom to purchase outside of the framework agreement. So I would say also depends on the interpretation of the member states. What is a framework agreement? Is there a binding obligation to purchase within or not? But following the wording of the directive, I would say that there is no binding obligation to purchase from the framework agreement only because I am a party to framework agreement, unless this is specified in the framework agreement.
Do you mind if I mean, the point, I think Madeleine is right in, I mean, I'm not, let me put it clear, I'm not playing the legal expert that I will not be, even if I'm born again. That's not the point. The point is that the director should not enter that word. It would be completely, you know, thanks God that we're in the UK, you know, kind of defending civilization against the ambition of entering those details. This is a matter of logic. A framework agreement, you know more or less what it is. Now, with the way it's going to be used, and because of this uncertainty we've been, you know, kind of emphasizing for a while, it's sort of it's going to the sensible use of the vehicle to make sure that you don't add any further uncertainty. So if I understood actually the problem of the framework agreement, so the idea that the same contracting authority might use two similar framework agreements simultaneously, right? Because when you made the first presentation some time ago, I got it wrong. I mean, you're saying I am the municipality of Rome and I'm using two very similar framework agreements for very similar stuff. Because if I'm using it for different stuff, there is no point. There is no overlap. So the point is, why would you do it? That's my point. So the point is, it goes back to the fundamental logic of good administration. For God's sake, why would a public entity award a framework agreement for pencils, right? And then maybe green pencils, and 2 days later for pink pencils? And whether they're put together. So it comes to basic logic of not being an idiotic public administration, right?
But
so that's the point. This is what I don't understand. Why we don't have to? Why we have one put so legal constraints where the story, the market. When I say the supply market would kill, parallel framework agreements because there will be a good one and a bad one. And so those in the bad ones will stop, the public administration from having the other one. So sooner or later, there will be only one surviving framework agreement. This is what I don't understand. Maybe I'm missing part of the picture, but from an economic viewpoint, I don't understand why would you ever see two parallel agreements on Earth. Sorry, Magdalena, I don't want to, this is not a ironic comment, but it's really, it addresses the point of, do we have this, in fact,
Yes.
in reality?
Yes, that was exactly the same question I was asking myself. Why? Why would they exist in the first place? But yes, they do exist.
But
And
if I may give an example, during the COVID crisis, we launched 4 different framework agreements with 4 different economic operators, because we need to have always some mask to sell, and all the economic operators didn't have the same ability to give mask to us. So to have several framework,
Why not one with 4?
because we need to have enough masks for all the public buyers in France, and the economic operators didn't have the same availability on masks.
So security of supply.
Yes, indeed. But it was
I don't understand the security of supply. You can have large framework agreements, with the, we have these US techniques of dual sourcing, triple sourcing, you name it, that's been used by the defense, by the Pentagon for 30 years. Not for mass, but for similar, problems. So having, competition throughout, stopping one, asking the other to go on. You have this for development projects, for weapons, but you can readapt this for in emergency circumstances. The sort of what they call in India the price, the unit price system, something like that. They have this for pharmaceuticals. And they have, extremely large framework agreements, and they worry about capacities. And so the only concern that they put an additional rule whereby in order to enter the framework agreement, you have to match the offer, the lowest bidder. But once you do that, you can have, hundreds of suppliers, and depending on capacity constraints, you go to the one to the second. Then, as Michael would say, you have to be careful because capacity constraints might be used to, to implement collusive agreement. But leaving this aside, the fact of capacity can be dealt with by having very large framework agreements and by, switching on and switching off suppliers depending on who has the standing capacity, who is constrained by capacity. So I don't see the problem.
Yes, but it's slower than to have several framework agreements and to select your own economic operators than to ask the first one in your framework agreement, do you have the mask, and then to pass it to the second. It's just faster, but I agree with you, it's possible.
Okay, well, I'm sorry, I know that parallel agreements is fascinating, but perhaps we have to go on because we are approaching the lunchtime. And so, but we will perhaps organize a third new seminar on that. But now we go to Denmark, and we have our Malina telling us about the
Yes, and I have some slides to you, if you would present them. In the meantime, I can introduce myself. I'm Malene from Denmark. I'm a lawyer and partner in the law firm Paul Smith, and we're also the legal advisor to the Danish government. So I'm always giving advice also to big purchasers and contracting authorities and ministries and also SKI, as we already talked about. And Michaela was supposed to be here, but she had to cancel because of some meetings. So if you can continue to the, you'll be my my helper here on the slides. I made an agenda with some points I'll make today. The next slide. Yeah. I think I'll skip. I'll take the conclusion of the first point, which is the legal definition of framework agreements in the Danish case law. Won't take you through the cases, but just deal with the conclusions, because I think this is what we need for the discussion. Then I'll focus a bit more on the situation after Autoritaire and Simonsen and Will, which have already dealt with the estimates and maximum values in Danish case law. That was a cliffhanger from before. Some points of suggestions to the amendments to the procurement directive as it is today, and then some further considerations in the end. And if we start with the conclusion on the legal definition of framework agreements, yeah, you can go to number 6, Julia, that would be nice. We have had some case law on how to define a framework agreement compared to an ordinary public contract. And the main assessment is how is the binding nature of the contract. There must be some kind of obligation if the contract is to be classified as a public contract and not a framework agreement. For example, we had a case on waste, collecting waste, and if the supplier has to collect waste every week, that's enough. It doesn't depend on how many bins are out every week. That flexibility is okay. It's still a public contract. So it's very much a case-by-case assessment after this judgment. That was very much discussed in Denmark, because there are some restrictions on framework agreements compared to duration, as you know, that are not the same on public contracts. So that was short on that. So let me continue to the situation in Danish case law after Simonsen and Wien and Autoritaire concerning estimates and maximum values. And just to recap for us all, what was the basic EU case law? First, we had the Autoritaire in 2018, and we had this famous paragraph 61 that states that you can only buy up to a certain quantity, and once that limit has been reached, the agreement will no longer have any effect. And then it was followed by a lot of consideration and discussion. Was this a new legal situation, or was it just an obiter dictum from the court? Because actually the case was about something else. It wasn't the main question. It just came out in this paragraph 61. So did the court really mean it, or was it just something that wasn't really to be dealt with? And if it was, how should we deal with this new situation? And several of these issues were actually clarified by the long-awaited judgment in Simonsen and Will case. That was actually a Danish case that came to the European Court of Justice. And that's on the next slide, Julia. Yeah, and that was the Simonsen and Will. And just to wrap up on that, what did it say? That was the famous paragraph 74. That says that the contract notice must indicate the estimated quantity and or estimated value, as well as maximum quantity and or maximum value of the supplies under the framework agreement. And then it said that it can appear either in the contract notice or in the tender specification if they're published simultaneously, which they are normally not in the defense directive, but normally it's the same time. And then it said that, very important, what was the effect if you didn't respect it? If you go back to it, what was the effect? Yeah, that the agreement will no longer have any effect once that limit is reached, which is very important because that can actually be costly, because that means damages and sanctions. Then it might be that you have made a direct award that has not been procured, and then you will have no effect and sanctions if you're challenged. Okay, so that was the situation. And then there were two further clarifications that were very much discussed in Denmark. And that was 70 and 71 that said it's not after the first euro necessarily that you don't have any effect, because you can actually allow changes as long as they are not substantial. So how much can you go over? Maybe it's not euro number 1, is it euro 50 euros or 100 euros? How much or how many percentages can you actually exceed the maximum before you are out where it's without effect? And secondly, they made a little clarification on where to state the different values compared to whether both documents are published at the same time. And we had a lot of case law. That was why I asked for case law in France and Italy, because we have actually had a lot of Danish case law on the subject. And to take the key aways from the EU, as I said, both the estimated value and the quantity and the maximum must be stated. Once a maximum is reached, the framework agreement will have exhausted its effect. The modification regime applies, and the maximum must be indicated in the contract notice or the tender specifications if they're published at the same time. And then to the Danish interpretation of how do we handle this? How has the contracting authorities, how did they handle the situation? And what has been challenged? And how did the board actually react on those challenging issues? And that's the next slide. I have chosen 5 cases that I'll just run through with you, and then I'll sum up with the key takeaways. So you don't need all the details of the cases, but it's good to know in what context it was challenged. And the first one is from February 22, and that was that was a case where there was an invitation to tender for a framework agreement on surgery. And it was challenged, that was the one, Mario, that the maximum number of operations was unreasonably high compared to the estimated. And you can see the estimation was 2 lots, and the first lot was 3,600, and the second lot was 2,400, and the max was 6,000 and 4,000. So 60% more or less. Was that too much? The answer was no.
Well, in France, it should be 500.
Exactly. That was very interesting.
But
yeah.
you know that in France, Supreme Court was against Simonson because there was a UGAP case in 2004 with the same text. They interpret in the other sense, and they say there is not an obligation for maximum amount.
Interesting.
And then they repeat the same solution in 2020, and it's because of Simonson that they changed in 2022.
Interesting.
But I have a question. Do you think it's needed to have a maximum amount in the subsequent contract also, or is it only on the...
Only on the overall level,
Yes.
I would say, until now. Yeah. Luckily.
Very bad. Very bad.
The second decision I'll take you through was from May 22, and that was an invitation to tender for a framework contract for paving works. And that was the first time we had something about services. All the other cases had been on goods. So the question was, does this also apply to services? We didn't doubt it very much, but it was first time in the case law that the board actually said, yes, it does. And then it was also challenged, how should you actually put this number in the material? Now you saw the quotations directly from the paragraphs of the code. And then when you compare to what was written here, it was challenged that the estimated value was only given through clickable links. So it was not stated, but you could click on a link, then you could go back to other documents where the maximum value was stated. Was that enough? No, it was not. I'll come back to that. Then there was the last one here from 22, Net Company, and that was an IT system that was challenged. And they were looking at the wording of the max. You see, they have been very much in details here, the lawyer taking care of those cases. Actually challenged, how was this actually worded in the notice? And they said, the amount indicated is an estimated upper consumption over 4 years. You see, estimated, that's estimation. Upper consumption, is that a maximum? Was that enough to make a maximum? And in this case, the board said, yes, that was enough. When you looked at the material and what was written elsewhere, that was clear enough. And the last 2 cases, the next one, McDick from February this year, that was a supply of aids. And again, it was challenged that it was unclear what is maximum, what is estimation. You have written in different places in the formula, you know, from the notices from the commission. They couldn't really see what was max, what was estimated. And in that case, they said it was unclear. They annulled the decision on award. And in the last case from September, you see it's quite new. That was an invitation also to medical products. And prior to the deadline for submission of tender, there was a question from the suppliers. And the municipalities, they replied that the turnover of the framework agreement is not expected to exceed a maximum amount. It's not expected to exceed. Is that a max? So you see, it has been very much detailed how to reply to this and how to word the exact amount. And if we make a overall picture, I try to make that for you on the takeaways on those 5 cases that will come now. Then you can see that the estimated values must be indicated, and that should be done simultaneously. And it applies both to the supply of goods and services. That was the PIAP case. We didn't doubt that very much, but it was first time it was actually stated. Also, the indications must be clear. That was said in the Coloplast care case. And on the other hand, it's really positive that the contracting entity, or the PBS, has a significant discretion in how to put the maximum. So the case I showed you with the 60% difference, that was okay. That was within the discretion of the contracting authority. What was decisive for the board was that there was an internal memo showing the considerations made before they put up the numbers. So they could actually explain, not when the case was there, but what they had thought before. And this is an advice I always give to my client.
That's the same as John Reed is doing.
Exactly. Whenever you take a decision, try to document it and put forward all the considerations at that time. Your lawyer will love you, because it's so much easier to go to court with such a memorandum than if you have to make up all the arguments during the case. And also in the public procurement material, we also do that when we take a choice. For example, we do a special trigger for a tendering procedure. Then we also try to explain it in the documents, because it's much easier to defend it when it's changed later. And they actually really put lots of weight into that in their decision and in the wording of their conclusion from the Danish board here. So
how many millions of euros in the pockets of lawyers are only caused by bad wording? That's amazing. It's amazing. I mean, I don't want to stop you here, but I will just add that if it were pure ignorance, then I would say, okay, that's fine.
Yeah.
It's fine that we transfer a lot of millions of dollars to law firm. But my worry is that in many cases, the bad wording is either strategic, so way of getting around other problems, or even worse cases. But it's amazing that there are case laws based on things like that. I mean, those civil servants should be fired tomorrow morning, all of them.
Yeah, it's not to cheat. It's not on purpose in that sense. I agree. But yeah, anyway, a safety margin was okay, which I think is really good for the contracting authorities, that they have some kind of space to operate in. The thing is that if the board finds that you have not complied with the maximum, you have not written it clearly enough, the consequence is serious, because it's annulment of the award decision. It was that in the PIAP case and the MEDIC decision, the 3 of the 5 I showed you, it was annulment, which means that the contracting authority or the PBS has to start again, make a new procurement. You have a gap, because what happens then, if you don't have a framework agreement or an agreement in the middle time until you get a new contract. So that's a problem in itself that we could also have a workshop about how do we handle this gap. It's a big problem for lots of my clients. And then the good thing is that in the Netcompany case, there was a certain freedom of expression. Even though the wording was a bit, you can say, loose, they said it was clear enough to constitute a maximum, which was not the case in the MEDIC. So it's also a case-by-case assessment, but at least there was some room of expression, freedom of expression here. But this is just to give you an idea about how the contracting authorities in Denmark have to act, because they're actually challenged on very detailed things. So this means when they write their procurement material, they really need to have lawyers at their side, because if you write your notice, you think, oh, it's really easier just to have to fill out this and this column with things. It might have really, really serious consequences.
It's not advertising.
No. It's just to me, no, but I come back to one of the conclusions about what can we change in the directive, because everything has become really complicated.
Yeah.
A solution for your clients.
Yes.
Why don't you put a provision in your former contract that if your new procedure is annulled, the former contract is
Extended.
Yes, extended.
Yeah, sometimes you can do that, but sometimes you only have the complaint with the former contract is already ending, and then you have a problem. Because it takes such a long time having those procurement cases, because if not, like we told you, then you can save it. Yeah. Okay. Yeah, we can take the next, because that leads to the next one, Maria. It wasn't an advertisement. It was just a. It was just to the next subject. So for about suggestions for amendments to the EU procurement directives. Because actually before coming here, I made a little informal survey to some of my clients, asking them, what would you say about framework agreements and what could we do better? Do you need any space for anything? And some of them said as first thing, it has become so complicated. Why can't we simplify it? Why do we have to have so many lawyers around us? And small entities, they really have problems handling this. As you also said, was it you, Gianluigi, that small entities, they don't want to spend time on this. It's too many resources to buy things. So could we simplify the rules? And could we also clarify some rules? For example, how to conduct a mini competition, or sometimes asked, can you do a framework agreement out of a framework agreement, or can't you? There's so many unclarified things as well.
Say it again, sorry, I missed it. Can you, sorry, say the question
again? Can you compute a framework agreement on the basis of a framework agreement? For example, if you do a framework agreement and then you make a mini competition, and then instead of having a fixed purchase, can you then make that contract running and not binding?
Yes, but you are limited by the duration of the first framework agreement to pass another contract. You can't pass another contract if your first framework agreement is already terminated. No?
If the first, then you can.
So a
you can
matryoshka of framework agreements.
Sorry?
A matryoshka of framework agreements.
Yes.
Yeah.
But I think
why would you do this? I don't understand this. Why?
Because it would be nice not to. Lots of bodies would like not to be bound to buy a certain amount, but have the possibility of buying things.
No, I don't understand that. If you go back to basics, the first lie that I always use, even with the Americans, is to say, at some point, uncertainty will resolve. That's the moment where the call-off is born. And if it's not the case, then it's still the first stage of the framework agreement. So there is always a way of reconducting any stream of operations to a two-stage process. If it's not a two-stage process, then there is something which is badly managed. So there is uncertainty and there is certainty.
Yeah.
Okay. Think of the quantity, the task order contract, the US tradition, the indefinite delivery, indefinite quantities. At some point, you know where do you have to deliver, how much gallons of fuel they have to deliver. If you still have uncertainty, that's not a call-off. That's not a task order. It's still an uncertain word. And so you can pretend that you have the second step of framework. It's completely crazy to do things like that.
But you could ask the market. Some markets might accept to do it anyway. But anyway, it's not clear whether you can do it or whether you can't do it legally according to the directive. And then there's a commercial aspect as well. I totally agree. Is it clever? Do you get good prices? And that's actually why some CBSs do mandatory framework agreements, because then you get better prices. Anyway, my last point is also, I think we have seen a lot of regulation concerning public procurement, but not in the directive. For example, if you go back, Julia, the new regulation on foreign subsidies, for example, and the new regulation on foreign direct investments, all the sanctions towards Russia, we have a whole lot that you also have to take care of in the procedure, because, for example, the FDI regulation, you have to make space for that in your time schedule for your procurement. If you have to have certain registration and improvements from the government and so on. So there's a whole lot coming around, which I think also is new in this context.
And green stuff.
Yeah, and green stuff as well. Yes.
And the social stuff and the green stuff.
And social, yeah, exactly.
Yeah.
And the last point, Julia.
Yes.
That was my further considerations that we have already touched actually today. Because I think that we see that as a supplement to framework agreements, we do more and more PDS, as we also talked about. And there are certain advantages connected to that. We could talk about the maximum amount also, but anyway, it's an open procedure compared to a framework that are more closed. It can take a longer duration as well. It doesn't have a time limit. And so also the time limit for the tendering procedure is very short. So there are lots of advantages, at least to some type of purchases that can be used as DPS. And I think that was my last point.
Thank you. Thank you, Marie. Now we have a short round of questions.
Yeah. So we don't have the case law that you have.
No.
But we changed our internal processes after the 2019 Italian one. So and we do it at a lot level as well. So if the lot goes past, effectively the lot.
Oh, yeah.
So we've had to redo the whole procurements just because lot 4 and lot 5, on the construction one. So we recompeted those two lots separately because we feel. But I mean, because we're a centralised purchasing model, our risk profile is different to some others. So we're naturally assuming that we can't go over that limit. We call it when the cut-off was full, basically. So we can't go over that limit, but we also do it at a lot level. Part of the guidance under the new rules say actually you're going to do that on framework level. So we're going to change that.
Okay.
We've gone too far.
Yes.
But no, we don't have the case study.
No.
We have the case law.
You haven't been challenged.
It's literally changed because of the what happened in 2019.
Yeah, interesting. Yeah, but then you have to be even more accurate because it's on the level of dots, which is further down in detail. Yeah.
And we get it wrong quite frequently.
Yeah.
A certain. I mean, I think because we speculatively did a lot for airports or for military stuff, maintenance, and then literally got taken up in weeks. So we got that one wrong.
Oh, that's interesting.
Yeah. And sometimes we get wrong, but it seems the other way around. It's not doing enough. But so but that's on the. As I said, it's not case law. It's a practical sense.
Yeah, exactly. And you have just been lucky not to have any challenges, no case law on that point.
Well, it doesn't help that the data's not very good. So therefore, it's good to know. But it hopefully we can get new data.
Nobody knows if the maximum has been reached. So
Exactly.
you never know.
Yeah.
Well, then I was thinking when you were doing your presentation, and all this, I have not been looking into anything in the new rules at UK level, but one of the new things at European level is these new e-forms, and the main reason for having this is the Commission wants more data so that they can control more and they can know where to set in and do things, right? So it's a hidden agenda there. But you're not having anything similar, or will you use?
So our transparency levels are going up. So there will be whole suites of new forms.
But you will not have e-forms. You have something that is only for UK.
Is it? Yes. Only for UK, but it's effectively the same.
Yeah.
But it's a lot more detailed than before. So simple. So when we do award for the competition on the framework, we have no idea at the moment. It's just you've awarded the framework. But we'll know that level of detail whether it's with competition or without competition. And obviously we're slightly different in the UK. We encourage them therefore to do competition on the framework. Whereas I think in the conversation today we probably less so in Europe. But it changes with whoever's in power. So,
But maybe you should be happy because the new e-forms are not very simple.
Well, I don't think ours are going to be very simple. But we're hoping that data will be dragged through because that's Italy has a unique identifier for each procurement, which we don't have at the moment. So we're introducing that, and then we'll be able to sort of follow traffic through the whole process, which we're looking forward to.
Yeah. Any other question or?
That's a very short comment to Malin. Thank you, Malin, for this survey of case laws. I was thinking, how many of those case laws would survive if we had a system and a standardized system for tender documents such that there is a line in which it's written maximum amount. Now, obviously, you cannot advocate this because you would lose a lot of business. So if I were you, I would never mention this to policymakers because that would increase your revenues. But at the same time, given that as an economist, I should work for social welfare, I would say this is one of the few circumstances in which mistakes or manipulations are just the outcome of human stupidity, that you cannot come up with a standardized way of approaching, especially a procurement vehicle such as framework agreement. So I guess that the Italian effort of making this big leap forward from sort of from the stone ages of procurement into the procurement 10.0, having a fully digital system, from end-to-end digital system, will help in that sense because leaving the digital part aside, the standardization of the way you have to provide information will kill all those cases. There would be a line, an estimated value, and that's the end of it. And with the joint effect of the fact you have to stick to 100. And then it's actually only when you have some problems at the go-off stage that you may add this extra 20%. But at the very beginning, put yourself into the shoes of CPB. CPB says, this is my market. A framework agreement is a sub-market of the whole market. And this is going to be the size of the cake. The size of the cake is 100, and it's going to be it. Now, call it estimated upper bound or whatever on any other German philosophical word, then that's it. It's 100, okay? And if you standardize this, if you standardize many other aspects, all those mistakes and manipulation will vanish overnight. And so, so there is a point why we want to push the system in that direction.
Good point.
Gianluigi, however, it remains a space for kind of what to say, a German philosophical approach, which is the connection, the ratio between the maximum and the estimated. Because here we have to use, as I see, the word discretion. It comes out that from Danish cases and also from the UK cases, it comes out something like the principle by which a maximum value of a framework agreement has to be reasonably carved out from the estimated value. Who knows what is this reasonable? In France, it's 5 times. In the UK, it's 60%. In Denmark, it's 60%. I think this is something very interesting because it's a kind of a new rule coming out from national decision, which will be, I guess, more sooner or later absorbed also by European law.
You're perfectly right, Mario. I mean, all I'm saying is that once you fix a constraint on the maximum value, and then you have to relate this to an estimated value of demand, and this becomes much more logical exercise. So this is why you have to be held accountable in that respect. And this is why we have further slides on our document saying, how did we come up with that value?
Yeah.
To show that we have, demands, that we have the guys who are, all obliged to use us. We conduct, surveys about demand, and we put all this together. We say, look, history says that if we estimate 100, we get, demand request for 180. So actually, we have the other problem, not the kind of problem that we inflated. So there are two, I think, logically different aspects. One is standardized maximum value. Maximum value means maximum value, the size of the cake. So what's the logic behind the maximum cake? This is another issue which comes into, and even if you allow people to do that in a very flexible, in a loose way, they fix 100, and they estimate 10, the market's going to punish them sooner or later.
Yeah.
So, and they won't survive. So I think that there are things that should be handled by rules, and other things that should be left to market management. In the UK, a contracting authority will be punished with very high prices. It won't survive if there is too much of a distance between the maximum and the estimate.
I share your faith in the market, but sometimes I know that. But I share it. I know. I agree completely with you.
Yeah.
So perhaps we should compare your case decision with the UK. You told me with the small municipality. Very.
It actually wasn't the court case. I've just said it to you, but it was going to go to court, but they retracted before it actually got to court. Unfortunately.
Okay.
So, but I said 7 billion. It was 70 billion. So you set the framework for 70 billion.
70 billion.
Yeah, but it's small.
Well,
It was more.
It got called. When
That
it
was
challenged.
Yeah, this strange idea of settling cases. So bad.
stand like them, yeah.
Such a shame.
Yeah.
Okay, now I think we can go to Spain
Yes.
and
Easier. Right.
Joseph is working for.
No, it's still avoid saying.
Okay, but like where they can.
No, but you can present. Well, first of all, I have to say that I'm a pharmacist, so not a lawyer. Focused previously in my presentation more in the green part of the frameworks or new initiatives, but I hope I can explain how we are moving with the frameworks agreements and organization. Our organization is a central procurement body for hospitals, which is centered in the healthcare sector. We mainly tender drugs and medical devices. So the EU regulation for procurement is not, we said, the best way to procure in the healthcare sector, because when we need a new drug, framework agreement lasts a lot of time, and this is why dynamic procurement systems are being implemented. We started as a central procurement body to implement the dynamic procurement systems for innovative drugs to reduce the time of getting the offer, 10 days. And now some other regions of Spain, like Valencia, they say that all the exclusive products will be procured through a dynamic procurement systems, because as also medicines are a very regulated product, so we have the European level authorization
and then the pricing reimbursement is fixed also by the Ministry of Health. So part of our work, procuring or tendering, is redundant, because when the Ministry of Health has negotiated some pricing options with, and also other discount and rebates with these drugs, it's quite difficult to obtain further discounts with innovative drugs. And the other, we are used that some of the companies do not present offers to our framework agreements, but we have to still procure them because we need them. This is why the EU directive, the procurement regulation, is not easy for us. Some regions, they intended, they copied a German model that for innovative drugs and not to procure them because as they were fixed by the EU government, by the EU, the Ministry of Health, then they were not needed to be procured or tendered. And one of the reasons was contested, now tendering again, and the opposition tried to put another regulation for allow them to. Regarding to the situation of reaching maximum estimation of volumes, I can explain our what we did. We started to increase 10-50% all the contracts plus the 20%. So just to avoid this kind of problems. Well, at this moment, we do not have some problems. Some of the contract frameworks only have been reached at the maximum, but well, I think we have not been advised for anyone. So at the moment, it's not a problem, but I guess this new jurisprudence in the EU regulation makes us, it's impossible that every one of us is applying a different concept. How to deal with this reaching the maximum. And I understand the suppliers need to need data in the offers to provide a good offer. So if they know that there is an invented data or invented amount, the offers will not be valid. Yes, and well, we are in the healthcare sector, we are introducing more dynamic procurement systems. Pros is that they are easier, they are especially for innovative drugs, for drugs with competence. It's not, that does not work, so we have to do it in framework agreements. The problems of framework agreements is that all the countries in Europe will have non-disclosed prices for drugs. And when we go to, because there are negotiations at the national level or member state level, so when we go to framework agreements, it's difficult to put these fictitious prices, and through dynamic procurement systems, it's easier because we can avoid publicizing the real price. The framework agreements allow the sector procurement bodies to also include other centers if they have not estimated previously the intention of procure, so it's easy for a center procurement body. And well, since the new regulation in 2017, because it was applied 3 years, the transposition of the EU directive was applied 3 years later. Now hospitals who procure by themselves, they can also perform framework agreements. Previously, they couldn't. But when they don't use it too much, the framework agreements at hospital level. No, now maybe I can look at the slides. It will go faster, please.
Yes.
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 Because it's there. Is there?
Yeah, you have to put F5 if you want.
Okay. Okay, it can.
Yeah. Good.
From Korea. And then select.
Yeah. This is a short explanation of what do we have. This is we are in the north of Spain. We produce mainly for hospitals. We are procuring 1 billion euro, 60% of medicines. Medicines are in the top 5. Well, from the top 10 contracts, the 5, 6 of them are contracts with pharmaceutical companies or region. And then most of the regulation is difficult to apply. The framework agreement is, as we know, and with, sorry, in Spanish.
Okay.
But from the healthcare sector, we have another option, is the clinical criteria for the awardee. And it's also a way of multi-awardees introduction in the contracts. Because some products may apply often with the same batch, they can have clinical differences. So, it's a difference between the others.
What is the criterio clinical?
Clinical criteria is that maybe the awarded product fulfills the criteria of the framework, but for example, contains a product that has an allergy, has latex, and another product in this has offered, has not been awarded, but has not latex. So as a hospital, you can procure the product that fulfills another clinical criteria that it was not explicit in the contract, because it's more safe for your patients.
So you have two options, with latex and with other things.
Well, we put, for example, one just this drug, but one of the products in the market contains latex and the other not.
Mm-hmm.
And I did not exclude the products with latex.
Okay.
But then at the moment of procuring, or at the final part of the contract, I can say that, well, I'm going to procure some of the products that have been second or the third one because they're safer for my patient.
Okay.
So sorry. So this is very similar, Joseph. It's very similar to what I called the sort of the matching mechanism in my presentation. So you basically put all the options, and so if you flag the no latex option, then you might have 3 surviving products, right? And maybe if you have the 3 surviving products, you choose the one with the lowest price, something like that.
Yeah. But most of the patients do not have a latex allergy. So I can procure the cheaper or the best one for most of the patients, but they still have, I can procure some products for the rest of the patients.
Mm-hmm. Okay.
Mm-hmm.
And then there's a dynamic procurement systems that we previously homologate all the pharmaceutical companies, and then when there is a innovative drug enters in the market, you can procure, vendor it. In 2-3 weeks, we have the contract, and with a framework agreement, we need 2-3 months.
Yeah, exactly.
But you could use a framework agreement in a dynamic system.
Well, actually, it's a framework agreement with a dynamic system. Yes, because we that framework agreement, we only certify the solvency of the pharmaceutical companies, but we and then we put a maximum estimated volume. Well, we put 1 million.
Yes, but it's not an obligation, because Simonson is on framework agreement, but not a dynamic system. But if you use a framework agreement in a dynamic system, here you must put a maximum amount. But when you are using a dynamic system, you can use also electronic auction, so you can be quicker also.
I don't understand it. If I was about to make the same comment. I don't understand why you embed a framework agreement in a DPS. It sort of kills the advantage of a DPS. I mean, I don't get it. I don't get it.
Well, is the way that if you with the performance framework agreement for a new drug will last 3 months until we have the contract. So we did a framework agreement with the solvency only of the companies, but we not put which products are going to be tendered. And then when we have a new product with the dynamic procurement system, we make a contract with exclusivity with only one. Well, only one company is going to have the product.
In fact, I think there's 3 advantages to use the two technique, because the first one, you can choose the duration of the dynamic system. The second one, you can add new technical, because it's an open system. And third, you can add also other economic operators. So I think it's good system.
It's a system we try to solve the problem of lasting too many time and too many efforts for a framework agreement, when you can establish criteria, but if it's exclusive to the product, well, whatever you do, they can fulfill it or not, but you have to buy that product. Well, and now some reflections about the introduction of green criteria in our tenders. The first of all is that the decision of procuring more health or green products starts before the procurement, and the selection of the products not only in the procurement, because some products maybe have not to be procured, or redistribute the number of the volume of products we are going to procure. So this is the health technology assessment, the assessment of the technology, part of the concept of the efficacy, safety, but one of these is impact on future generations, that will be the environmental concern of to introducing the selection of the new products. Since last year, in the HTA process in the national level, introduced some of these environmental assessment in the drug. For example, for this new drug, they say that apart from efficacy and safety, this drug is persistent and toxic to the environment. So it's a concern, and maybe you have to deal with that, or take into consideration also in the selection. Other cases you already know is anesthetic cases. Between the anesthetic cases, the student is the most one that has the most impact in the environment, so it has to be avoided. So maybe not to procure and procure the rest of it. And also in others with prevalence, it has most impact on the prescriber who decides which kind of inhaler, with its one dry power or prevalence, that's different. And also, for example, now we are performing a tender, a framework agreement with recycled and recyclable polyester clothing. So it's the focus of the framework agreement is not for all the products, but to a restriction also only with this kind of products that are more environmentally friendly. Some of the discussions are also in our practice because, for example, in drugs, in Spain we use the unit dose, so all the drugs we procure in the hospitals, we want to have the identification for each of the pills. When it's not in the market, we in the hospital we perform a repackaging to provide this, and this is one of the most impact with a lot of wastes that we are producing. Implementing the unit dose in the clinical as a criteria in the framework agreements, it has some environmental impact because it reduces the number of repackaging you have to do, but you have to consider that other options or without all these blisters would be even with less impact. So the discussion of the impact is not only introducing criteria, it's also implementing new strategies in the hospital. We initiated after the introduction of the law, was in the transposition of the EU directives, and we introduced social clauses and environmental clauses in the framework agreements. They are aligned to our organizational commitments. And for example, in our central procurement body, not during the pandemic, it's not introduced any environmental criteria. Because it was a moment to focus on other things.
Prices, for example.
And now we are trying to implement. We observe that many of the companies they are committed with this, with environmental criteria and modifying the products. And now we are in 80%, and since next year we're introducing all the framework agreements, all the contracts are explicit environmental criteria. Explicit because I say that other criteria can also contain somewhat of environmental impact that we were using in the past, but these ones are going to be explicit. So, and it's also because the EU directive allows that, because some of these criteria are not so many related to the object of the contract, more related with the company, not with the contract, because maybe the environmental system of the company is for the company, but it's difficult to say that it's also related with the product. It should be, but we are asking to the company. And also the weights of these criteria in the framework agreements, and this, like last year, was 1.1 point out of 100, because the weight in the criteria, and we expect next year to increase the weight to 5%. The criteria thing, it depends on the focus, the different focus of the products, environment, the supply chain, impact on the patients, the people, and this is the current criteria we are introducing in medical devices and drugs, especially in packaging, because packaging has a lot of impact in drugs, how they are supplied, and also the energy or the water that is used to produce the product, and the commitment to reduce the carbon footprint, and also to have data, because when we are, one of the problems is we are organizations, they are implementing strategies of reducing carbon footprint, but we don't know the impact of these products. So companies now, they are working on developing on data, on providing this data. But not all of them they have. So it's like a signal to the market that they have to evaluate the footprint of the products. Under consideration now is green chemistry practices and also animal welfare. And these are some examples that we are using now. Immunomycin system. It's not really related with the product, it's related with the company, but and also the packaging criteria to reduce the impact of the packaging.
Why don't you use it as a minimum criteria? I mean,
Yeah,
with this one,
exactly.
I mean, you've run a market intelligence and find out that the first one, the EMS, you find that all of them would be compliant, because if most of the market is so let me rephrase it in a more, I would say, in a broader term. One of the purpose of sort of environmental sustainability is not just to put here and there, is to push the market in a particular direction. So after a while that you've been using a particular criteria as an award criteria, it should become a minimum quality standard. Otherwise, there is no point so there is no push, right? So as you observe the market evolving, and they will evolve because that's a huge bargaining power, they will evolve in that direction. At some point, this is acquired. That becomes a minimum quality standard. Then you can add more sophisticated or even more, I would say, ambitious while talking to Danish people.
Well, I think the market is getting prepared, but it's not really prepared at this moment. And also after the pandemic, avoiding some of these offers, because now, although maybe they are not the awarded, they are in the framework agreement. So in case of a shortage, I can use these companies or these offers because they are already in the framework agreement. If I exclude them, well, if I have a shortage of a drug or a medical device, I have to launch another framework agreement. Yeah, I think it's a strategy to resilience of the contracts. But I agree, when the market is going to be more mature, we can implement them as a minimum criteria.
No, Giuseppe, you see that my point is, if you put, the number of points is not enough. It's basically no one is gonna sort of find it worthwhile making the investment. So the point is, either you push hard in that direction so that the whole market was there, or it's going to be, what's the point? I'm going to lose 2 points. What the hell? I'm going to put a level price and that's it. So all I'm saying is it makes sense to use it as an award if it's very heavy award criterion, because this becomes a big incentive. Otherwise, the market is not going to move in that direction, especially if you buy, I would say, a relatively low fraction of the overall demand. Now, in our case, I can tell you, for instance, our DPS for pharmaceuticals, when the region of Sicily uses our DPS for their 2-year estimated demand, it's a contract for thousands of lots in the order of 2 billion euro. I can tell you that this is a huge push, for companies. So either you aggregate a lot, and so that otherwise, if the number of points is too limited because you're afraid that some of them will not be able to comply, that's not going to be a big incentive. This is my point. Sorry.
Yeah, well, I agree, but the problem is, as a central procurement body, we procure for other hospitals, and then the question is, how much cost is a hospital want to assume to buy a more environmental friendly product?
That's the point, exactly.
And at this moment, I would say that 5% will be the maximum at this moment. Maybe they have to be more committed with the environmental policies, but it's difficult to convince them that to increase this way.
Okay.
And also, not also the hospitals, the government who funds the hospitals maybe has to provide more funds to provide this more environmental. When this is safe, it's not a problem, but it's an increased cost, it's a problem.
Yeah, that was my question in connection to that. How much increase of cost have you seen? You have put more and more weight to the award criteria concerning environmental affair. So what about the cost? Has it been the same?
No, because we have excluded some of the cheaper, especially medical devices, and well, we assume a 1 or 2% of increase of the cost.
Okay,
Not bad.
No, that's fair.
that's right. So it's not equivalent, so to speak,
No.
which maybe means that the market is going the same direction.
Yeah, we are going slowly, just in case to avoid a contract of 10 or 20%
Yeah.
increase.
Yeah,
But
because
you see, this was my point. This was my point. If the market is going, so you have to kind of get a sense if they're going that direction because they have other incentives from the private market, from any other, public. So if they're going in any way in that direction, this is a further reason for setting it as a minimum quality standard. This is what I'm saying. Otherwise, if you are if you're the front runner and you are among the first ones given that incentive, then you have to be more aggressive. This is it. So if the market is going there, so put it as a minimum quality standard. That's my theorem.
Yeah, it's a question of whether you follow the suppliers or the suppliers follow you, right?
Yeah, who's pushing who?
Yeah.
We're trying to
It's
push,
intertwined.
but I have to admit that other central procurement bodies, they are not still implementing environmental criteria, and now we are being copied because some of these criteria are being used in other framework agreements for other central procurement bodies. But to push the market, we have also to go together with the different procurers, the different central procurement bodies, align with which criteria we are going to introduce, and then increase the minimum standard.
And in all countries.
And in all countries in Europe, because the market is quite global.
I have a question. On your slide 20, you talked about the patient. Do you introduce the patient need in your criteria? The patient, you talked about the patient in your 20.
Well, no, some products, because they are delivered to the patients.
Yes, but do you introduce the need of the patient in the way you buy the product? For instance, when you buy latex for the glove, you can have some allergic reaction with the patient. So, in your criteria, do you introduce the need of the patient when you're buying?
Well, we try to introduce, for example, for products that are delivered to patients or directly to patients, we try to introduce them. For example, now we are preparing a framework agreement for monitoring glucose devices, and apart from consulting the professionals, we are in a focus group with patients, because which device is also a more easily patient-friendly or easy to use, and maybe we'll sort out a criteria from this focus group.
Yeah.
And do you think to the medical team also in the way you are?
Yes.
Yes.
Well, the demand or the necessity of the product is from the medical team, and also the government, because the products are needed, but for some products that they are going to be delivered for patients, patients, we are trying to introduce this kind of focus group.
Mm-hmm. Okay.
And this is my last reflection. In environmental criteria, we have a problem of certifications, which certifications are valid and which are not valid. It's difficult to assess all the which is environmental fulfills the environmental criteria and not, and there are a lot of certifications that are independent and difficult to compare between them. Also, as mentioned, the value of this social and environmental criteria in the products, the innovation of the sustainability, and also introduce different kinds of tenders or agreements, like cooperative projects with companies, the innovative procurement, and also the adoption of innovation, because there are not new products in the market maybe that they could contribute to be more environmental hospitals, but maybe with framework agreements are more difficult. Maybe with innovative procurement are more easy to introduce.
Well, thank you. Oh, I think you already had some questions during your explanation, but if there is something else, we can. No, it was exhausted already. So no, I think we can finish here. Thank you very much for all the participants. Now then we will decide with Karina how to use this very precious material, and I think a lot of good ideas, new ideas, and possible also proposals for modification of legislation. And we will keep in touch, of course. Thank you also for our friends on the other side of the screen, Gianluigi and Michael.
Thank you. Mario, would you share the presentations among
Sure.
participants?
That's the
Thank
first
you.
thing to do. Thank you.
Thank you so much.
Thank you. Bye.
Bye, Michael.
Thank you. Bye bye.
Okay, now we have lunch. Always, please.
Under forhandlingerne er udbestilt tid, så så foreslår vi fra dansk side at have rammeaftale, ikke rammeaftale. Ja.